Okay, Vasudha, you can proceed now.
Yes, sir. Good afternoon, all. To all respected, distinguished resource persons, faculty members, research scholars, and my dear participants. I am Bhaskar Shapkath, student at Department of Law, Central University of Karnataka. It is with great honor and privilege I you on of Central University of Karnataka to the plenary session 2, Women, Crime and Society, a cross-sectional analysis. Over the next 50 minutes, we will delve into the critical issues surrounding women, crime, and justice, guided by three distinguished scholars from across South Asia and beyond. To begin the session, I have the honor to introduce our first esteemed speaker, Dr. Vittiyaiye Teeroovengadum, ma'am, lecturer at Middlesex University, Mauritius. Ma'am is a seasoned consultant in the field of international trade law and has worked in academia for more than a decade. She has lectured at various universities in Mauritius, at Paris, Nanterre University, France, and at Vittiyaiye University in India. She has been working as the legal officer for the Higher Education Commission of Mauritius for a few years. She has a PhD in International Law and Sustainable Development from Paris Nanterre University, France. She is currently pursuing a postdoctoral degree in the field of public international law. We welcome you. It is my privilege to introduce our second speaker, Professor Richardson, ma'am, Dean Faculty of Law, Jagannath University, Dhaka, Bangladesh. Ma'am is a dedicated academic and legal scholar. She completed her LLB and LLM from the University of Chittagong and later earned a second LLM in international law from South Asian University, New Delhi, under the prestigious Srtarts Silver Jubilee Scholarship. Her career began at Eno Salish Kendro, a leading human rights organization, and she later served as a faculty member at the University of Chittagong, Dhaka University, and East West University. As the founding chairperson of the Department of Land Management and Law at Jagannath University, she has been instrumental in academic development and legal education reform. Her research interests include women's rights, gender and law, refugee law, and international criminal law. She co-authored the book Women and the Law of Citizenship in Bangladesh and is an active member of Prof. Sexual Harassment Redress Committee and the Board of World Concerned Bangladesh. We warmly welcome you, ma'am. Now it is my honor to introduce our third distinguished speaker, Professor Savita Naayar, ma'am, Professor, Department of Law and Director, Women's Study, University of Jammu, India. Ma'ams hold an LLM and PhD degree specializing in gender issues, criminal law, constitutional law, and human rights. Throughout her career, she has taken a leading role in academic and outreach initiatives, organizing gender sensitization workshops, awareness program on topics such as National Girl Child Day, and contributing to discussions on gender-biased violence and legal protections. Additionally, she has been instrumental in guiding youth engagement through thematic discussions like Vikshit Bharat 2047, Voice of Youth. I warmly welcome you, ma'am. Now, with the great pleasure, I invite our first speaker of this session, Dr. Vittiyaiye Teeroovengadum, ma'am, to deliver her keynote address on the topic Act of Violence Against Women, Scrutinizing the Role of International Court of Justice. Ma'am, we welcome you to share your valuable thought with us. The floor is yours.
Thank you. Thank you for the very nice introduction and the kind words from you. It's a pleasure to be here today. Bear with me with the connection issues. I'm having these connection issues since yesterday. So I would like to thank first Dr. Jagannath for his invitation and the organizers. It's a very nice initiative from the Department of Law of Central University of Karnataka. Can you all hear me properly?
Yes, ma'am.
Okay.
Yes, ma'am.
So I'm here since this morning. I'm quite impressed by the presentation and it's very enriching. I would like to salute this initiative and the whole organization. It must have been very tedious to bring all the presenters together and to ensure such an organization. So the topic for today is very relevant. It is a topic which is even more relevant because of the different happenings, new technologies, AI. AI is disrupting all fields, whether it's education, whether it's any field, especially criminal law. I've been teaching cybersecurity for some years now, and I would say you can't imagine the number of crimes that's happening and the type of crimes that we are having here in Mauritius and elsewhere. So I'll be saying a few words on the acts of violence against women, a scrutiny of the role of the ICC. Before talking about my topic, I would, if you're all okay with that, I would just, I prefer to switch off my camera because of the connection issue. Are you able to hear me properly without any
Yes,
background
your
sound?
voice is perfect. Your voice is perfect.
It's perfect. Okay. So I will just switch off, and if it is okay, I will switch it on.
Ma'am, as per your convenience, ma'am.
Okay. Thank you, and I'm sorry for that. My sincere apologies. Okay. So I'll be talking about the acts of violence against women and the role of the ICC. I have been working on a paper previously on theories of IR and the ICC. When we talk of international law, it's completely different as compared to national law. The international field, it's an area of law which is very specific. Okay, how do you enforce these laws? It's a completely different mechanism as compared to enforcement of laws in a country. Okay, because when we talk of an international field, we have so many countries with different legal systems, with different laws, and protecting themselves from each other by this principle of sovereignty. Till these different countries, they agree to come together, they sign treaties, and they agree to abide by the different provisions of these treaties. But to what extent are these provisions enforceable? Okay, this would be discussing in a few minutes. So before coming to my topic, I would say a few words on the theme of the conference. Micro-narrative to meta-narrative, it's really relevant. There has been a shift in paradigm, not now, it has started decades ago, okay? When we have discussed about, previously many presenters have discussed about what is a crime. A crime is not like any legal issue, okay? A crime is against the state. It is against the state, and the prosecution has to abide by various parameters, I would say, okay? For instance, you have this principle, the presumption of innocence, to be proven guilty, to be presumed to be innocent until proven guilty by a court of law. So many principles which are there protecting the individual, okay? Proving the case beyond reasonable doubt. This is very specific to criminal law. So micro-narrative have certain specificities. The focus was more on individual cases, on localized justice. Each country has its own legal system. For example, if we consider the UK, you have the common law legal system, very specific. How the courts are organized, how the laws are interpreted, okay? How the government is organized, how the principle of separation of powers is being enforced. If we consider, on the other hand, another category, for instance, the Roman law legal system, which is enforceable in France, it's completely different. In the UK, you have an adversarial system, just like in India an adversarial system where you have two parties fighting for a case, presenting their case, and you have the judge, which is neutral and coming up with a decision. In France, it's different. We have the Roman law legal system, where you have, for instance, the criminal justice system is different. It is inquisitorial. It's not adversarial. The judge can intervene and ask questions as compared to the adversarial legal system. So it's completely different. If we compare, for instance, now Mauritius. Mauritius, we have a hybrid legal system. And very often, the legal system of a country is linked to the history of the country. Okay? So in Mauritius, because it was colonized by the French, then it was colonized by the British, we have like a mixed legal system. Okay, all the procedures would be just like in the UK, but the substantial law would be just like in France. So it's different, it's a hybrid. So with countries having their own laws, their own legal systems, now these countries have to collaborate together in an international era, in an international field. Can you imagine how complex it is? Okay, so we have to, when we move from micro-narrative to meta-narrative, there are so many issues, okay? So many issues, for instance, with regards to the model. Which model should be adopted, okay, in this international field? And this model should be adaptable to all the different countries. When we talk of transnational justice, okay, which should be applicable to all these different countries, what would be a proper provisions which would be adaptable to these countries? So I would say that the shift is not happening now. The shift has been happening for decades. And I would say now we are in a catalyst mode because of new technologies, because of AI, because of new crimes, and because of new perspectives, okay? Having said that, let's talk about violence against women, because this is my topic for today. Why we talk of equality, equal gender, and then we talk of specifically violence against women? Is this not discrimination? This is a question to ponder on, but let me give you my perspective. For me, these two genders cannot be treated equally. Each one will bring its own specificity to the table. We cannot be equal, right? Because we have our own specificities. Otherwise, violence against women would be irrelevant and discriminatory. However, I'm a feminist, okay? Don't get me wrong. I'm for equity, okay? For equity. This is why violence against women is very relevant. So when we talk of violence against women, you have so many types of violence. It can be physical, for example, domestic abuse. It can be, it can be sexual assault. It can be rape. It can be honor killing, which is still happening in some countries, but which would be completely irrelevant in other countries. Okay, acid attack, which is something very common in one country, but it is something completely not imaginable in another country. You have psychological violence, gaslighting. Now you have online abuse. So an abuser can be sitting in country X and abusing someone in another country. Okay, structural violence. Okay, where you have, for example, child marriage, forced marriage, so many crimes which is targeted against women. Okay, and we have specific legal frameworks for these different crimes. For example, you have the UN Convention on Elimination of discrimination against women, very specific. You have UNSCR, which is linked to peace and security, and it's very broad. At the same time, it's very specific to women. You have the Istanbul Convention, which is more recent in 2011, on which is more regional, okay, with regards to the Europe binding treaty on prevention of violence against women. You have the Rome Statute, which we'll be focusing on, okay, which is used by the ICC to prevent such crimes against violence, and which has recognized rape, sexual slavery, forced pregnancy as war crimes. Women's crime, violence against women is being perpetrated on international level. So having discussed about these different types of violence against women, I'll be talking about the different issues which is being faced by the ICC, okay? When we talk of violence against women, it's kind of a straightforward topic, okay? You have these different crimes and they are recognized as being crimes, okay? However, how do you enforce? Even at national level, think about, we are all in the legal field, think about enforcement of laws. Laws can be very well drafted. If we have a look at, for example, the laws I've been teaching in India too, I was very much impressed by the constitution in India. Very well drafted, so many rights. However, when we consider the enforcement, it's not just India, it's even in Mauritius can be even worse. When we have a look at the enforcement, it's something else. The laws can be well drafted, but the enforcement is something else. So imagine now at national level, it's so difficult to enforce law. At international level, it's even more difficult to enforce the law, okay? Because you have, for instance, you have this principle of sovereignty. Countries would say, yes, we agree to sign these different conventions. We agree to abide by these different provisions. But when there is an issue and they have to abide, this is something else. Because when we talk of the international field, we have something known as the game of powers, okay? These different countries, they have different level of power. It can be linked to the level of development. It can be linked to the collaborating countries. It can be linked to the regional force of that country. Okay, so it's even more complex to enforce law at international level. Okay, so creating narrative of global justice, it's very difficult, but there is a need for it. There is a need for it because we can't tackle criminal acts of violence against women without moving to this next step, because now it's a global village. It's all the different countries are connected. Can you think of a country now which decides to be completely independent? It is not conceivable. We are living in a global village. I'm aware of my time, so I would, don't worry, I will be concise and I will focus on the gist of the topic, okay? So there is a need for meta-narrative. There is a need for global intenses to take action. The ICC is, for instance, a court which allows this shift from micro-narrative to meta-narrative. Okay, it's facilitates this shift. I'm not saying it's perfect. I'm not saying that it's doing its job correctly. I'm saying it's facilitating and it's enabling this evolvement, okay, this transition. There has been so many examples where the ICC, before criticizing the role of the ICC, let's talk about what's positive. Okay, what's positive? The ICC has been prosecuting so many crimes based, for instance, on the Rome Statute. Crimes against humanity, for example, sexual slavery, enforced prostitution, war crimes, okay, sexual violence in armed conflict. Dr. Prema, who has been talking previously, would be the one who would be well suited to talk about sexual violence in armed conflict. Okay, you have so many examples of sexual violence in armed conflict, and the ICC has been intervening, even if it is moderately, I would say. It has been intervening to allow this development. Genocide, for example, which is provided by Article 6 of the Rome Statute, where you have acts intended to destroy a specific group through sexual violence. So the court has helped to codify these different crimes, okay, and has helped to recognize these sexual offenses, which are acts against women, as a standalone war crimes and crimes against humanity. Okay, so you have so many cases at the ICC where they have stood up for acts against violence against women. For example, you have the case of prosecutor against Bamba, a case of 2016. Okay, in that case, it concerned Central African Republic. Okay, which dates 2003. In that case, he has committed various atrocities, okay, such as rape. Rape was used as a weapon for war. When we talk of war, sometimes if we talk of war, we just imagine soldiers fighting against each other. However, if we go deeper in the atrocities which are committed during war, one major atrocity would be rape, okay? And it's used as a weapon. In that case, for instance, the ICC convicted based on Article 28 of the Rome Statute. The court ruled that Bemba knew and should have known that his soldiers were raping civilians and should have taken action. Okay, and the rape was organized and in such a manner that it was considered as a weapon for war. And the court has ordered for reparation through the implementation is quite slow. This is one example. There are so many examples. For instance, in 2019, you have the case of Bosco. Okay, the case of Bosco, which concerned the Republic of Congo. Okay, so in that case, it concerns sexual slavery of child soldiers and systematic rape. Even in that case, the ICC has ruled that sexual slavery was used as a weapon. They have abducted girls who were used as wives for the soldiers. And they have recognized that these girls were forced into marriage, and it was recognized as a crime against humanity, a crime against women. And the court has ordered similarly. Yes.
Sorry to interrupt, ma'am. Can you please
wrap
make it
up?
brief? Because
Yes,
we have
yes.
technical sessions.
Sure. Yeah.
Ma'am, please don't mind.
Yes, sure. Actually, this is a topic which I'm passionate about. If you give me the floor, I would be talking for hours. But don't worry, I'll wrap up in a few minutes.
Ma'am,
So
definitely will invite for another session, ma'am.
Yes, sure. So as I was telling you, you have so many cases and you have an ongoing case. For instance, you have the case of Al Hassan, which I guess most of you would know, which concern the Mali Islamic occupation. Okay, so this is quite an interesting case because the ICC did not hesitate to take a stand, even if this involved religious belief. Okay, so I would say the ICC has taken stand, but to what extent has the ICC really been involved? Okay, there are many criticism in the role of the ICC, in the role of this court, what is provided by the law and what is being enforced. Okay, it is being criticized by so many scholars. Okay, and I would say that now the law should be rethought. There should be a shift in paradigm because there are new crimes. There are new crimes and there is a new mindset. Okay, for instance, let me take a simple example. Some decades back, 5 decades back, for a woman to be a businesswoman, she should have got the permission of her husband. Okay, otherwise it would be a crime in Mauritius. However, if we take the same example now in 2025, it is inconceivable to have such a provision. This is a simple example, but this simple example, if we take it at higher level, it's the same thing. There is a shift in paradigm. And this shift in paradigm is not happening in one country. It's happening in all countries. Of course, in some countries, it has evolved so quickly. In other countries, it's taking time. Even the global field is evolving. So there is a need to have better strategies, better laws to involve these shifts to happen. So I would end on this, and I would give the floor to my colleagues to continue with this very interesting conference. So thank you everyone to have been listening to me. I hope you have learned something, and I hope I've been able to share my insight on this topic. Thank you so much.
Thank you so much, ma'am, for enlightening the session. Your insights on how international legal frameworks can address violation against women have brought a global legal perspective to this deeply rooted issue. We are sincerely grateful for your contribution. Now I take the honor of inviting our second speaker, Professor Christine Richardson, ma'am, to deliver her keynote address on the topic, Criminal Law and Women's Rights. Ma'am, we now invite you to express your valuable perspective with us. The floor is yours, ma'am.
Thank you. Is my am I audible?
Yes, ma'am.
Yes, ma'am.
Yes, I'm audible, ma'am.
My apologies in advance if there is any technical problem. Actually, suddenly, sometimes it happens. So, can I speak without the video?
Yes, ma'am. It's up to your convenience.
Okay. Thank you. It's because of the technical difficulties. Okay, I may be coming on and off. Okay. So before I begin, I want to thank Dr. Jagannath for reaching out to me and giving me this space to share some of my thoughts on criminal law and women's rights. Actually, I'd be speaking about the criminal law in Bangladesh and how it addresses women's rights. So, and thank you also to the University of Karnataka for this program, which is very relevant, actually. So, when we speak of crimes against women, crimes against women it happens more or less all around the globe. So the question is how each state deals with these crimes, actually, specifically the crimes which are committed against women, starting from sexual crime, sexual harassment, assault, rape, torture, trafficking, murder, domestic violence, and so on. We can carry on with the crimes, especially now, and this changing global situation, the AI and cyber crimes also, where women are being attacked. So, since I'll be speaking in the context of Bangladesh, so what are the criminal laws we have? The criminal laws which were adopted to keep which were keeping women's rights in mind, and some specific special laws were adopted to protect women from specific crimes. We have the penal code, which is more or less same like the Indian penal code, that is covering the crimes in general, including women. So besides that, in Bangladesh, there are special laws which have been adopted, so to give special protection to women. So among these laws, one of the special laws was the Women and Children Repression Prevention Act, which was adopted in the year 2000. So just let me specifically mention some of the laws. We also have the Dowry Prohibition Act, which is also a big problem. And this act we adopted a new act in 2018, actually, repealing the previous Dowry Prohibition Act. The Domestic Violence Act, Prevention and Protection of Domestic Violence Act, was adopted in 2010. So these are specific laws which were intended for the protection of women from the specific crimes which were committed against women. So going back to these laws, the Asset Offences Prevention Act, which was adopted in 2000, we have seen this act has been effective. And this act was actually to mainly, it was regulating the production, sale, storage, and transportation of corrosive substances. Because at one time, before 2002, there was a rise in acid crimes, women being attacked using acid. So whenever there was any problem, maybe even family issues, stalking, in those cases also, women were being attacked by throwing of acid. And then in 2002, when this act was adopted, actually the state took a very strong stand against this crime. And the crime has drastically dropped since the adoption of the act in 2002. Now the question is that this act has been effective, and the crimes have been dropped, and there are very scarce incidents of acid now in Bangladesh. But the Women and Children Repression Prevention Act 2000, the Domestic Violence Protection Act, the Dowry Prohibition Act, these are also adopted to prevent the crimes, to protect women from those specific crimes. Now, why haven't these acts been as much as effective as the Acid Offence Act? So one observation of mine, going through these acts actually, and the even the response by the state, not only the state, the total criminal justice system, if we look into it, the beginning with women going to complain to the police, that is the first obstacle which she faces, because there are less female police officers. Even if there are female police officers, sometimes we see that they are also not properly oriented, and even sometimes they are not gender friendly. So let alone the male officers. And then the next obstacle that they face is how they're going to continue with the complaint, and finally when they go to court. So there is a free legal aid is being given to women by the government. It's provided there's a Legal Aid Act. However, there is no law or whatever on the fees of lawyers. So sometimes women face the problems that they cannot afford a lawyer. They cannot get someone to speak for them. And another problem that I think in the whole mostly in South Asia, which we face, the time that's required in disposing of the suits of any cases. So especially for women in Bangladesh, where they face a lot of, there are religious, social barriers also. Traveling to and from court and continuing this for year after year, it becomes very difficult for women ultimately to get justice. So the acts that I was talking about, the Women and Children Repression Act and the dowry prohibition or the domestic violence. Another problem is that behind why these acts have not been very much effective, because in these sort of cases, wife beating or dowry or sort of domestic violence, which may not be in a very also high scale, there is some sort of societal tolerance we see. Even the law enforcing agencies sometimes they're very reluctant to intervene in this sort of matters. So in that case, due to the societal tolerance and gender insensitiveness in some cases, these crimes against women are continuing, and women are not able to get proper justice, though the criminal laws are there. Coming to the present Bangladesh situation, these laws are there. These laws have been used in the country, but as you may know, or everyone maybe is aware of the present situation in Bangladesh right now, that in last July, August, during this time in 2024, there was a mass uprising to overthrow the government which was in power at that time for about 15 years. So during that time, in that uprising, a good amount of women and girls were also, they had participated in the movement. And during that whole time that the movement was going on, women very actively participated. Sometimes they even acted as a shield when police were attacking the other male protesters. And with these thousands and hundreds of people on the streets protesting, at that time there was no incident against women at that time, any sort of sexual harassment or these sort of things. But what we see that after the movement, when the previous regime was overthrown, the new interim governments took power. And then there was a totally shift. Due to that movement, the women activists and all, usually the women in the country, there was an expectation that maybe the thinking pattern has changed. Women participation, their public appearance, this has been taken there's more acceptance towards women. However, that after the new government came into power, it was a very depressing situation for women. What women had expected, that maybe they would be recognized, their rights would be more addressed. But what we have seen, the incidence of rape increased. Women started being harassed in public. Women, the feminist female activists were supporting women's rights. They were attacked. Even in two places of Bangladesh, villages especially, there was a women's football match. 2 football matches were vandalized. And then also in public, there was issues of dress. So why are you dressed like this? And or in some areas, it was declared that women cannot go to the tea stalls and drink tea in public. So it was just like a total shift of what women expected. So why this situation? During the whole movement, women participated, women were used, even they were welcomed to come into the movement. But just when everything was according to the expectation of those who started the movement, the attack started on women. So, and these criminal laws, which we have existing criminal laws, these laws are there in place, and this situation is now on the rise. So why are these laws not being able to protect women? Where does the problem lie actually? Was it during the movement situation because men also were equally vulnerable? They, the whole men and women, everyone, they considered themselves vulnerable. But when there was the shift of power, and though a lot of girls, women participated in the movement, when the interim government was formed and student leaders were taken into the government, there we see also women were not being properly acknowledged. And just in the 6 months of this year, in 2025, there has been a report of 481 rape cases just in the last 6 months. And different forms of violence has been also reported, which there was an amount of 558 incidents of violence. So at this point, the criminal laws, why are these criminal laws not able to, these laws were promulgated keeping women in mind, keeping the crimes against women in mind, but these laws are not being very much effective right now. If we go to the meta narratives actually about women's rights in Bangladesh, there has been a read petition to the High Court Division challenging the legality of abortion, prohibition of abortion in Bangladesh. So this is a shift, actually. The petition is still pending in the High Court Division, though. But this is a shift that where women's right to abortion and the law has been challenged. But just observation on this petition, we see the petition is more on heavily relying on Roe versus Wade, and it addresses the right to privacy or the right to choose of women. So even when we see these laws are made, or even there's challenging something, there is still that patriarchal thought in there. We cannot, I think, come out of that boundary of
Extremely sorry to interfere, ma'am. Can please?
I understand actually.
You are bound by times, ma'am.
Yes. As Dr. Vitti also said, actually, when these are actually very close to our heart, and that when we start speaking about these issues, like we can carry on.
Yes, ma'am. Yes,
So,
yes.
no, it's okay.
Okay, ma'am.
So coming to the, I'll just close. So actually, why we are not able to still protect women using these criminal laws? So unless actually we have a shift in thoughts and if actually gender friendly, we need more gender friendly judges actually, which we see in a reflection when the cases relating to women are, when we study the judgments. We need more gender friendly judges actually. And as long as these laws are not effectively enforced and the perpetrators are not given exemplary punishment, the violation of these rights will keep on continuing. So we need not only we need a change in the whole criminal justice system actually. So unless there's a change in the whole criminal justice system, we are not going to be able to properly protect women's rights using the criminal laws. So saying that, thank you everyone for hearing me patiently. I hope I could point out some of the Bangladesh issues. Thank you.
Thank you so much, ma'am, for enlightening the session. Your insights on how criminal law protects the women's rights has truly helped us. We truly appreciate your contribution, ma'am. Now it is my privilege to invite our third speaker, Professor Savita Naayar, ma'am, to deliver her keynote address on the topic Crime Against Women with specific reference to sexual harassment. Ma'am, we warmly invite you to share your valuable insights with us. The floor is yours, ma'am.
Thank you. Am I audible?
Yes, ma'am. Exactly.
Am I visible? Because I'm not visible on my screen here.
Actually, no, ma'am. It is blackout coming, so screen is black.
Screen is black.
Your video is on, but I think there is some technical issues in the device.
Okay, just wait.
Yes, ma'am. Now it is perfectly visible.
Okay. Thank you. Thank you so much. Uh, First of all, I congratulate the organizers for organizing an international conference on a very, very relevant theme. And in that, you have covered the various areas, and the woman specific areas is also one session. So I feel honored to participate in this session, and I will do my bit to contribute something in this conference. And although the time is very short, so I will also quickly point out my concerns about the crimes against women. As the topic of this conference is from micro narratives to meta narratives, reimagining criminal jurisprudence in a globalized world. So I'll try to relate these two things, micro narratives and the meta narratives, as well as in the how to reimagine the criminal jurisprudence in the globalized world. So as we see that on the one hand, we are talking about this gender equality, gender justice, and more and more women should come out and get the education as well as to work. And on the other hand, we have this global perspective of the human rights. Every human being has the right to live with human dignity, right to privacy, and everything right from the Universal Declaration of Human Rights in the year 1948 and the various international conventions. But still in 2025, we are talking about the crimes against women and their right to live with human dignity, as well as having the safe the spaces. Not only this problem is confined to India, but it is a worldwide, as a crime against women is the universal phenomena. Now, the woman, as like any other human being, has the equal right to live with human dignity. And for that perspective, there are a number of human rights conventions. The constitutions of different countries, like the Constitution of India, also speak about right to life and personal liberty, as well as the right to live with human dignity, which gives the right to women also to have the safe spaces, not only within the home but also outside the home. And when the women, they are doing every bit to work to create a niche for themselves, as well as it may be in the politics, in the leadership, in sports, in education, everywhere, in science and technology, but still they are not feeling safe. And more so when they are not safe in those institutions which are their protectors, like the educational institutions, the workplaces, or the homes, then it becomes a cause of concern for the researchers as well as for the law students and we who work in the criminal law area. Now, if we look at the statistics from we can say from east or west, or from north or south, or from Odisha to Karnataka, or from Bengal to Delhi, we find that the violence against women has been seen an ominous rise over the past few months. Although in the year 2023, Indian government made a new law, changed the criminal law and brought the 3 new laws, like repealing the Indian Penal Code, Criminal Procedure Code, and the Indian Evidence Act with the BNS, BNSS, and the BSA. But still, if we look at the figure in the year 2025, there is ominous rise in the crime against women. So what is more appalling is that these crimes are committed in such spaces which are supposed to be the safe spaces for women. So as the earlier speaker also pointed out, that the protection of women, what to do, that is the cause of concern, where we have gathered in this conference, that's reimagining this criminal jurisprudence in a globalized world. So although when this Vishaka case happened, we had the International Convention on the Elimination of All Forms of Violence Against Women, which talked about what is the sexual harassment and how to eliminate all the violence, where all the countries who signed this convention, they pledged that they will work towards the elimination of violence in their respective countries by making different laws and taking different measures. And in India also, there was a lot of efforts made to make the law in alignment with this convention, but the Shaka happened, and then the Supreme Court also gave the number of guidelines to address this issue of sexual harassment of women at workplace. But still, we could not, the law could not see the light of the day. And we try to provide justice or address the grievances of the women by looking at the different laws, sometimes towards the Constitution, sometimes towards the Universal Declaration of Human Rights or the International Convention on the Elimination of Violence Against Women, or on the criminal law. But still the crimes against women committed day in and day out. Then in the year 2012, the law was made, and which got final shape in the year 2013. And the 2012, another horrific incident of Nirbhaya happened in Delhi. So in the year 2003, we could see this law, Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act of 2013, which mandated all the workplaces to constitute the internal complaints committee, because looking at the criminal law, going to the police station itself is a challenge. And sometimes even at the police station, the women don't feel safe, and there also they suffered violence. That's why this law pointed out both types of remedies, one at the remedy for the internal complaint committee and another remedy for the visiting the police station and filing the complaint there. But what happened now? Recently, we have seen the case of Alasur, and there also that 20-year young student who had the sharp mind, who could train a number of other students who could be very, very fruitful asset of the society, but still she herself suffered the sexual harassment and committed the self-immolation, because she could not get the justice while running from pillar to post. She was doing the B.Ed, and she has to train the student. She had to become the teacher. That was her dream. But still, the system failed that student, that bright student. So where the fault lies? On the another one hand, we repealed another law. We made the new criminal laws, and we made the number of changes, made the law stringent. So there are a number of measures which have been taken by the Indian government also, like the various schemes have been formulated, the laws are been made stringent, but still day in and day out we are we are hearing the news of violence against women here and there, and more so when such violence happens in the educational institutions. Then where to go? When this protector becomes a predator, then what to do? It means somewhere we are lacking, and that gives us the food for thought, and that gives us the work to do. That just like when COVID happened, the scientists, they worked day and night that how to deal with this disease. In the same way, this disease of crime against women, this is increasing day by day, and this has really become cancerous. So we researchers, if we will not do work now to find ways and means, not only for making laws stringent in a day-to-day basis, but we have to provide more preventive measures, because whatever crimes we find in this national statistics, those crimes are only tip, because the number of cases go unreported. So how to deal with all those cases? Although the reported cases also give us a shocking picture, but still the unreported cases are many more. So here the job comes, the job of the researchers, that how we people who are dealing with these issues, who are dealing with the gender issues, women issues, who are dealing with the criminal law issues, what we can suggest that how, and that's why this conference has been planned to deal with number of the issues which the society is facing, how to deal with issues. That should the concern. That should be our concern, that we should put something concrete that should be laid before the policymakers, so that these problems can be eliminated from the society. And my suggestion is that although the laws require the stringent measures, but still they require the strict enforcement, because certainty of the punishment is more important than the stringency of the law. Because laws, no, the BNS had made more punishment, stringent punishment. Death penalty for rape on the girl below the age of 18 years. But still, the rapes are happening. Number of rapes are increasing. The sexual harassment is increasing. It means the certainty of punishment. Somewhere the criminal knows that he will not suffer. He will manipulate the evidence. He will manipulate the witnesses, because the justice system is dilatory. the justice delayed, justice denied. Although justice, this speedy justice sometimes also justice hurried, justice buried, but still, the need of the hour is, although the zero FIR and various other provisions had brought a lot of changes, which gives confidence to the victim to approach the criminal justice system, but still more is to be done, and that required just like the CCTV cameras, because sometimes the evidences are manipulated, the witnesses are manipulated. So these recording, we find that sometimes the videos are reach in each and every corner of the society, where the lawmakers, they are also compelled to are the persons who are enforcing the law. They are so compelled to do justice. They cannot sit in silence over those issues. So this digital evidences, like the forensic evidences and the implementation of law, by making the people aware, sensitized, as well to speak more. But I'm scared that at this B.Ed student, she spoke. She ran from pillar to post, but she could not get justice. So the need of the hour is that those persons should be taken to task who have to implement the law, who have to enforce the law, and who have to provide the protection. For instance, if the internal complaint committees, they are not constituted in different institutions, what to do? As the law says, that we have to find those institutions with at the first instance, the penalty is 50,000, but still nothing has been done. I have not heard anywhere that this penalty has been caused. Their licenses have been suspended. If from 2013 till this date, the organizations, they have not made the internal complaints committee, or if the internal complaint committees are formulated, but still they are only on papers, or for example, they are not constituted according to the mandate of the law, and only those members are there which may hush up the case, and the reports may be biased. So external members should be made mandatory, or the more accountability of these members should be there if the justice is not provided, or within 90 days, which is the mandate of the law, the complaint is not addressed. So now the time has come that all of us have to work together, and we have to put forward before the policymakers that although the making of law is very, very important, but more than that is implementation of law, because the criminals, they are not scared. They know that they will commit the crime and then they will escape the justice, they will escape the punishment. That's why the more and more crimes are being increased day by day. And so we have to devise these measures, that prevention of crime is more important than the punishment. So for preventive measures, we have to adopt the measures like the internal complaint committee, this CCTV cameras, the awareness programs, sensitization programs. All these things are very, very important if we really want to protect the women from different types of crimes which are committed against them. So as the time is very short, so I, with these words, want to conclude my session. Still, if the organizer permit me more time, then I can throw light on a number of other issues also, or like with the help of case laws and other, I can put forward my point. But still, if the time is short, as I have to chair another technical session also, that's why, keeping in with the paucity of time, I'm concluding my session with these words, that implementation of law and the awareness of law is sensitization is more important than anything else. Thank you. Thank you very much.
Thank you so much.
Thank you, ma'am. Thank you. It was nice of you, ma'am. Actually, in international conference, many paper presenters are there, so we need to do justice with all of them. Anyways, ma'am, you are in contact with me anytime. We will definitely arrange a special lecture series. That is what international conference gives us. Network.
Thank you.
And with this, I would like to extend a formal vote of thanks. And first, I would like to start with Dr. VT ma'am, who has deliberately given a very insightful lecture on a topic of act of violence against women, and she scrutinized the role of international court and international justice. Also, she touched upon very, comparative discussions between Mauritius and other countries, and we have got an insight of France Justice Administration, which is quite different from our system. Followed by Professor Dr. Christine Richardson, ma'am, Dean, Faculty of Law, Jagannath University, Dhaka, Bangladesh, who has given a very insightful this discussion about the Bangladesh criminal laws regarding the protection of women. It is very nice to have some, multicultural analysis, and as far the theme goes, it was rightly justified by her deliberation. Next, my senior and my mentor, in one sense, I have been with her for last 1.5 years. I know her, Professor Savita Naayar ma'am. It is very nice of you that you have come here. You have dedicated your time and effort to deliver on a very wonderful lecture. And I have seen you are the director of women's studies of your university, so you are the right person to guide us with respect to the women rights and issues involved during criminal jurisprudence. So with this, I would request Savita Naayar ma'am that to join with another link that was shared to you, and that technical session will immediately start. And at the same time, I also request Christine ma'am. Ma'am, are you here?
Thank
Richardson,
you.
ma'am?
Thank you. I will join the next session. Right?
Yes,
Yes.
I'm here.
Yes,
Thank you.
ma'am. You will also have to join with that different technical session link, ma'am.
Yes, I
And
will.
Vitti ma'am, Dr. Vitti ma'am, actually you will be staying back in
Yes.
this link only.
Okay,
Here only we will
okay,
start the
thank you.
session.
Okay.
All paper presenters of technical session 2E and 2F are requested to move to their respective technical sessions.